dear speakers, dear participants. My name is Roman Nekolyak, and I work as the International Relations Coordinator at the Center for Civil Liberties. Today, we will host a lecture about crime of genocide. This lecture will be recorded, and you can revisit it later at CCL YouTube channel or CCL Facebook page for your educational purposes. I will be a moderator of the event, and you can ask questions in the chat or voice them directly by raising your hand at the end of the meeting. If you new to our platform, I will briefly explain. Center for Civil Liberties is a Kyiv-based NGO. We operate from 2007, and last year we received Nobel Peace Prize. Today, I will host a talented speaker from United States, from West Coast, I presume, because it's early morning at your house. We will speak about the crime of genocide under international law. Professor Townsend will tackle several core issues of this most violent and most brutal atrocity crime. He will speak about actus reus and mens rea, Latin term, and we will decipher them together. He will speak about protected groups, relevant international jurisdiction, about as of state responsibility and individual criminal responsibility for the crime of genocide. He will speak about the key evidence, tipping the scale in some cases before international tribunals, and he will speak about potential application in the present conflict in Ukraine, in Russian aggressive war, Russian invasion of Ukraine in 2022. Why Professor Gregory Townsend is the best suited person for such a lecture is because of his academic, scholarly, and particularly international criminal law career. For the last 20 years, he has served as a ICC duty counsel, International Criminal Court in Hague. He has served also in the UN International Criminal Tribunal for Rwanda on genocide trials. He worked in UN mission in Kosovo, the UN International Criminal Tribunal for former Yugoslavia, Special Court for Sierra Leone on the trial of President Charles Taylor. And today, basically 1 hour ago, we listened the lecture of Professor David Crane, the founding chief prosecutor of UN Special Court for Sierra Leone, your colleague, Professor Townsend. Also, Mr. Townsend worked for the special tribunal in the case of Lebanon and UN International Residential Mechanism for Criminal Tribunals, a framework organization, and we will touch it a little bit later. After Russian invasion of Ukraine in 2022, Organization of Security and Cooperation in Europe, OSCE, add him as a list of experts for the so-called Moscow mechanism. And I remind you that Center for Civil Liberties participate in Moscow mechanism submission. Finally, Professor Townsend, also an expert for CCL partner and co-organizer of Ukrainian International Criminal Justice Week, the co-organizer of this event that's happening right now, Public International Policy Law Group, PLPG, an international human rights NGO, think tank GRC, Justice Rapid Response. Professor Townsend, the floor is yours.
Thank you so much. And thank you personally, Roman, for the kind introduction and all of the organizational work you've done in setting up. And it's a real honor to be here for this Ukrainian International Criminal Justice Week. We have just until the hour to talk about genocide as a crime. I have only about 8-9 slides. And Roman's kind enough to share the PowerPoint. And there are a couple slides. Great, thank you so much. On development of the crime. And then we'll talk again about the elements and then some practical examples. So feel free to go to the next slide if you wouldn't mind. So just in terms of laying the ground for the development of this crime, the crime of genocide was effectively shepherded along by its real godfather, Raphael Lemkin, who, as many of you know, went to law school in Lviv, lived 1900-1959, coined this term, and he's the real force behind the 1948 Genocide Convention. And so what makes genocide in some ways unique, at least it was, especially in 1948, and when it entered into force in January of 1951, was the fact that it's an international treaty. And so it has aspects, and we'll kind of conclude on this point, as to public international law and international criminal law, which touches on individual criminal responsibility. There's a YouTube video here, which may or may not play. Effectively, I would encourage you to just do a YouTube search for genocide word Lemkin, and you'll get this very nice 1.5-minute clip. And you'll get to hear Professor Lemkin effectively use the word in his own voice for the first time. Although he's talking about quite some collateral issues, you'll find some other things. So I just wanted to give credit to him. And he was in that law school classroom, the same law school classroom in Lviv as was Hirsch Lauterbach 5 years earlier. And so they had the same criminal law professor, and Philip Sands goes into great detail in this part of history and development, which is fantastic to read up on if you're more interested in this crime. You can go to the next slide if you wouldn't mind.
And actually, I can try to show the...
We'll try to see if the clip, it's 1 minute and 13 seconds or so. Let's see if it works. I think we have the spinning wheel and 1 minute 13 shown.
Genocide is a new word combining the Greek word genos meaning race or group, with the root of the Latin sidere meaning to kill. Dr. Raphael Lemkin, who is a professor of law at Yale University and specializing in teaching matters about the United Nations. Dr. Lemkin is the man who created the word genocide. Dr. Lemkin, could you give us a little background on how you came to be interested in this genocide?
I became interested in genocide because it happened so many times. It happened to the Armenians, and after the Armenians, Hitler took action.
Lemkin became the leading force behind the drafting and adoption of the International Convention on the Prevention and Punishment of the Crime of Genocide, adopted unanimously by the United Nations General Assembly in Paris on December 9th, 1948.
I would urge, and I think that's the spirit, the unanimous view of the Assembly, that this convention be signed by all states, ratified by...
That's probably enough. I wouldn't worry. We can go to the next slide. I guess what's interesting, takeaways there, is you see that his first obsession really was with the Armenian genocide that's taking place really contemporaneously with the World War I by the Ottoman Empire, and how at that point in time, in the terms of the development of international criminal law, killing one's own citizens didn't constitute an international crime. And there was protests against it in the Declaration of 1915. So we start to see individual criminal responsibility developing there. The second thing we're talking about is it's 1948 in Paris, where the development of this is happening the day before the Universal Declaration of Human Rights is happening. And so that's 10th of December. The day before is the adoption of the Genocide Convention. So you see these two things working in parallel, the development of human rights and the development of international criminal law. Looking here at this development here, 1933, Lemkin is a prosecutor in Warsaw, and he's still very much interested in trying to advance international criminal law. And he comes up with his first proposal. I call this sort of his first draft. In 1933, he writes a proposal that the international community should adopt a crime called acts of barbarity. And he sends it off to a conference in Madrid, and no one really acts on it. And his bosses in the prosecution office in Warsaw don't let him attend or travel for this. And so it sort of collects dust and is there, but you can see that he's been working on it for almost a decade before it actually gets any traction. In 1942, war's already broken out 3 years at this point, and there's a Polish government in exile in the UK. And he sends a proposal with, shall I call it the second draft, where he says we should coin the term Völkermord, the killing of a Volk, a people. And that's his, shall I call, second draft there in 1942. Again, Polish government have other things really more pressing to deal with, and this professor doesn't really get much attention out of this. It's not till November of 1943, with the publication of a thick book called Axis, Rule in Occupied Europe, Chapter 9, he coins the term, and as in the interview and the video clip shows, he combines the Latin and Greek terms to create the killing of a race. And so that's where the term comes up from, that he coins, he gets credit for it. What's kind of interesting, as you can see in the development and evolution of this concept, and it's not really a legal concept, it's just sort of, I should say it's a legal concept, but it's not a very firm legal concept until 1948 in the convention. What he's really talking about is the Nazi Aryanization of occupied territories. And so not even what's happening in the Holocaust in German territory, but effectively only what's happening in the occupied territories. And Lemkin effectively manages to get his way into the US prosecution delegation in Nuremberg. And Justice Jackson sees him as a disturbance and annoyance and has him sort of sent back and not to return. But he proceeds in 1945 in the phase of the very first Nazi Axis trial from 1945 to 46 of the principal leaders, the 22 that are tried in Nuremberg in the main international trial with the four powers, to get the term genocide for the very first time published, not just in his own work, but in the indictment. The charging instrument in Nuremberg charges that in 1945. And so it's born there. It's interesting when you flash forward to the closing arguments of that very first Nuremberg trial, is that 3 of the 4 prosecutors referred to the crime of genocide in their closing arguments, but not the US delegation. And the judges, much to Lemkin's dismay, doesn't refer to it and makes a finding that crimes, including this so-called crime of genocide, only take all of the crimes that they find convictions for only are during wartime from 1939 forward. And so all of the atrocities that occurred before 33 from the Nazi rule to 39 were just ignored. And so the question is why? And I think there was a certain sense from the judges there that this was not sufficiently settled law, and that the states in judgment there had vulnerabilities on their own treatment of national minorities, and that this finding offenses not at wartime would make them vulnerable. So by limiting it to wartime, they could point the finger at the Nazis and not have it turned back at them. And even though this term genocide, sorry to go back just a few more quick points, is that where it's listed in the indictment, it's not in the same conception as we have today. It's listed under the broader heading of war crimes, and it's listed as killing civilians, but limited to 2 groups, racial and national, in occupied territories only. Okay. Now, flash forward after the Nuremberg trial and judgment, the UN, mostly because of Lemkin pushing so much and being the godfather of this crime, adopts a resolution. He's really the ghostwriter behind all of this. But he's basically have to build a political coalition of non-great powers. And he is the force behind this resolution 96-1 of 1946, where the UN says we should work towards creating a convention for genocide that applies not only in wartime, so it would apply equally in peacetime. And that's the big issue for Lemkin. And what are the groups identified in 1946? Religious and racial, and political and other. So it's really to have an other category is what we call a catch-all a wider category capable of being expanded. So really wide net potentially. Political has lots of implications. Those two ultimately never make it in, but religious and relational are. But what's also notable is that 1946 version also does not include national or ethnic, whereas national was already listed before in the IMT indictment. So you see lots of fluctuations and, shall I say, a certain fluidity and a lack of real clarity on what this crime is going to be. And ultimately, the motivation for Lemkin is to protect groups. And ultimately, there are 4 groups enumerated in the Genocide Convention and in most domestic laws, although there's some difference depending on different states. But the goal is to protect groups, whereas the crimes against humanity regime that's basically fostered by his contemporary of Hirsch Lauterpacht is really an orientation to protect individuals, and particularly civilians, as we know. Okay, so next slide, if you wouldn't mind, would be great. So let's dig into the actual text of the Genocide Convention and try to understand, beyond this development, what is this crime? So genocide means a specific prohibited act, and there's 5 categories of acts. And so that's the objective physical perpetration aspect. And we'll look at those in just a moment. So if you commit one of 5 one act that fall within one of 5 categories, then that's the actus reus, and that's the objective act. Now, what differentiates this crime from all others is the special intent, what's referred to as the dolus specialis. The intent here is the intent to destroy in whole or in part, and then 4 groups are protected: national, ethnic, racial, or religious. Then there's these 2 words tagged on at the end, as such. And those words are really, really important. And I always ask, what do you think those 2 words are there for? And effectively, to want to destroy a member of a group, one of those 4 groups, as such, what we're talking about now is saying they're being targeted because of that affiliation and membership in the group, because of that appurtenance, before that, these are all national, ethnic, racial, religious groups that are people born into. So these are traits that you're born with, and effectively it's because of the way you are and who you are that you're being targeted. And so those as such mean it's not just killing people in a national grant by random or by chance. It's because of that affiliation that's genocide seeking to cover. And importantly, Article 1, and this was the big chip on the shoulder of Mr. Lemkin, was that this crime has to apply in time of peace or in time of war. If we go to the next slide, if you wouldn't mind. And again, please feel free to pose questions. Raise your hand, put it in the chat, save it for the end, however you wish. I'm really happy to make this a dialogue as you wish. So this is the text on the left-hand side of your screen of the Genocide Convention. I've underlined a few key provisions. And so Article 1, again, whether committed in peacetime or in war, that was a really important thing because of, again, what Lemkin viewed as the failure of Nuremberg to prosecute the crimes from 1933 to 1939, before the outbreak of international armed conflict. All of the atrocities basically were unpunished. And he said, no, there's probably millions that perished in this period that really needed to. And it reminded him again of the Armenians. So this was the big differentiation for this crime. And I think it's important to note that because of that judgment in Nuremberg, holding narrowly that crimes against humanity only applied at wartime, that was the state of the law until about 1995, when the appeals chamber of the Yugoslavia Tribunal held to the contrary, that crimes against humanity they do not need to occur in wartime. And so taking that element out was a really important precedential element. But again, the conception from 1951, the entry in force of the Genocide Convention, until the 1990s was genocide was the only thing, because war crimes had to apply. War crimes against humanity was then viewed as applying only in war. Genocide was the only crime that would apply in peacetime. So what's important here, also notice that it is an undertaking of states in Article 1 as a matter of public international law. So states are making promises to cede their sovereignty and make promises to, quote unquote, prevent and punish genocide. And so that obligation means you can bring a case to the International Court of Justice, as well as eventually haul an individual before an international criminal court or domestic court. So that's Article 1, really important points there. And then Article 2 is really the whole black letter elements of the crime. So let's look at Article 2 a little more closely. In the present convention, genocide means the following acts, again, as we've talked about, with intent to destroy in whole or part a national, ethnical, racial, religious group as such. So four groups only. Political's not there. There's no catch-all other category. If you don't fall into one of those four groups, you're not protected by the Genocide Convention, perhaps unfortunately. I mentioned 5 categories of acts. The 5 categories of acts appear in Article 2 at the 5 letters A, apple to E, echo. So we do have killing and everything. When you think of genocide, most people immediately say, oh, okay, there's this massive killing, extermination, that's a genocide. That's only one of 5 categories. And so that's obviously the most obvious, and it's perhaps the signature of genocide is a massive extermination based on a group of pertinence. But going beyond that, I think it's really important for you to understand that the B, C, D, E provisions are really significant here as well and qualify as genocide. And so B is talking about causing bodily or mental harm. So those terms are really quite wide and subject to wide interpretation. And so I think it's important to highlight here that in the very first judgment of an international tribunal in September of 1998, the Rwanda tribunal convicted a certain mayor named John Paul Akayesu. And Mr. Akayesu set a precedent in his case in being the first individual to be prosecuted under an international court for the crime of genocide. And the Rwanda genocide, killing 1 million people perhaps in 100 days, qualified as a massive killing, category A of acts. But there was widespread rapes of Tutsi women by Hutu perpetrators. And the judges, mostly led by the female judge, Navy Pillay, who became High Commissioner for Human Rights, as president of the Rwanda Tribunal, and not the presiding judge, but one of the 3 judges in that case, she insisted that the crimes of sexual and gender-based violence be heard and amended to that case. When the witnesses gave statements, they didn't mention being raped, but when they came to court, they said that they were raped, and they were raped in the presence of the mayor, Akayesu. And so they said that those rapes qualified as an act of genocide under the category B of causing bodily and mental harm to those victims of the sexual and gender-based violence, and that those acts constituted acts of genocide. And so really important to understand that we're not just talking about killing, but a wider category of acts therefore led to a conviction of genocide in his case, amongst others, including, of course, killing, but it wasn't limited to killing. And that's an important second precedent in Akayesu. The third category, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. That category, what we're really sort of thinking in 1948 is this sort of post-war death marches or death marches of people from camps. They weren't felling people with bullets or blows to the head, but rather just starving people, having them march out in the winter, do Sisyphean sort of tasks just to tire them out and basically drive them to their deaths. And people would not return to camp in the same numbers as they left. And so that slow motion genocide, if you will, is this third category, deliberately inflicting conditions. And so that category is also perhaps applicable in other more current contexts. If you can think about places where minority groups that fall within those four groups are inflicted to horrible conditions, and perhaps you can think of people being forced to be deported, forcefully transferred away from their homelands. That category is a separate category of acts. Imposing birth measures intended to prevent births under D. David. This is obviously inspired by the Nazi Holocaust and this idea of preventing births and directing things at women. The bigger picture here is in the development of these categories of acts. There were three rapporteurs from 1946 to 48 following that resolution and leading up to the meeting in Paris to adopt the Genocide Convention. Three rapporteurs, and they took three different approaches, and they looked at cultural and a biological approach, and the biological destruction effectively won out. What's interesting, though, is that the fifth category under E. Echo, forcibly transferring children of the group to another, was an act that was developed by the rapporteur focusing on cultural genocide, and the Greek delegation that experienced this forcible transfer of Greek children during the Nazi occupation effectively insisted that this was part of their experience and that it should be prosecuted, and they felt that they were the victims of a genocide, in fact, in the World War II period. And so that's the only thing that makes it out of the cultural genocide proposal into the final genocide act, and it's included. And obviously, in light of the ICC prosecutions bringing a arrest warrant for transferring children, that makes it perhaps the most interesting debate, is whether we've crossed the line from a crime against humanity, a war crime of transferring children from one group to another. Is there the intent to destroy here? Is there a group that's qualified? Is it targeted as such because of that appurtenance? And does the act of forcibly transferring children in the Ukrainian context cross the line over to an act of genocide? It's not part of the warrant as of now, but that's a live issue and could be an interesting question for discussion. So those are the 5 acts, A through E, listed under Article 2. But what distinguishes genocide from all other crimes, again, is this high-level intent and the group obligation that the victims have to be targeted as such as part of those 4 groups. Now, on the left, I mentioned that this is from the Genocide Convention. And on the right, what do good lawyers do in Rome in 1998? They cut and paste. So why would you reinvent the wheel to define the crime of genocide in 1998 if there was already an applicable treaty on this? So, of course, what you see on the right-hand side of your screen is the ICC Article 6 Rome Statute definition of genocide, and you'll see that it's almost word for word. It's basically a cut and paste from the Genocide Convention. Makes sense politically not to redisturb this definition. But as we see, there's some small wrinkle that happens. So in 1998, the states agree. Now we have 122, I want to say, states parties. This is the not just the convention, Genocide Convention, but the Rome Statute, perhaps the more recent version. I think there's lots of commentators would say, and the ICJ has held that the prohibition of genocide is a peremptory norm of international law and a customary notion. So the definition remains there, the same as the convention, but there was a small development after Rome. So the year later, in 1999, and I saw there's a question, I'll come to it just to finish this slide, if that's okay. In 1999, the Yugoslav Tribunal of the United Nations, set up by the Security Council in 1993, has a trial in the case of Goran Jelicic. And Jelicic, pictured here on this slide, had 31 counts against him, and he was happy to plead guilty. But he was not happy to plead guilty to the one count included of genocide. So the war crimes and the crimes against humanity, more than happy to say he was guilty of sin. But for genocide, he said no. And so rather unusually, rather than just accepting the guilty plea to 30 some odd counts and convicting him and dismissing for the interest of justice this extraneous thing he won't plead to, because it wouldn't affect the sentence probably, the prosecutor insisted, and they ran a trial, not on the 30 counts, but just on the one charge of genocide. And the question was, did Mr. Jelačić, who referred to himself as the Serb Adolf, did he commit the crime of genocide? And so in a week of evidence, the prosecution called witnesses. And what did the witnesses say? They said he killed a lot of people, but he killed a lot of people at random. And he let some Bosniaks go and killed others, and didn't kill exclusively Bosniaks. And so the judges come to the conclusion that he's mentally disturbed, a homicidal maniac, but not a génocidaire, that because he killed not with an intent to destroy in whole or in part, but because he's just a maniac. And so they found at the end of the prosecution case, the defense didn't need to even put on any evidence. And so it was a no case to answer decision. They said Jelačić is not a génocidaire and he's acquitted, and we're just going to proceed to sentence him on his guilty plea on the other 30 some odd crimes. And so again, this takes place a year after the statute of the Rome Statute's been signed and done. And so states are looking at this decision and say, well, this is one crazy guy, and he's charged with genocide, and he's not necessarily doing it on instructions from his state. If we have one guy, we'll call him a lone wolf, acting alone, proceeding to kill people based on this group appurtenance, they're going to be able to brand him as génocidaire, and perhaps our whole state will go into ill repute. We don't like this idea of one guy committing a genocide. And so as a direct result of the Jelačić decision, the states are meeting a year later in year 2000. They're still working out the ICC's, not its statute, that's 98, but they're still working on the elements of crime document. And so the elements of crime document, really important document because it lists all of the particular elements for each and every offense under the Rome Statute. If you aren't familiar with that document, go do a search and download it. You'll find it probably in whatever language you want. And so when their states are still gathered to talk about the elements of crimes, they realized politically in Rome, they couldn't change the elements. And there'd been already water under the bridge because it had already been signed and done. They couldn't change the treaty, but the elements of crime they could still effect. And so all of the Article 6 genocide elements of crimes definitions all include this language that appears at the bottom of the slide in green. And so this is a new additional element that exists only at the ICC and not under the Genocide Convention. And what does that language say? I read the green text that the conduct in question, so the criminal acts, one of those 5 categories, that conduct took place in the context of a manifest pattern of similar conduct directed against that group, or was conduct that could itself affect such destruction. Okay, so now they're putting this sort of contextual threshold element into the crime of genocide if charged before the ICC. Now you ask yourself, we've just looked at crimes against humanity that need to be widespread or systematic, and genocide, we're going to use slightly different language, has to be part of a manifest pattern of similar conduct. Is there a huge difference? Probably not. A very small nuance, but effectively states wanted to make sure that when the ICC brought a charge of genocide, it wasn't a lone wolf, it wasn't a one-off kind of guy. Now, the words that appear after the or in that, conduct that could itself affect such destruction, for me, that's maybe you could have one person who has a button, who has a finger on a button that can effectuate a really wide level of destruction, that conduct by a single person that could destroy a whole group in a single blow of a single person's act, well, that category they wanted to not exclude. So that definition has to have a little subtlety there. That's why the or is there. But effectively, no lone wolf genocide under the ICC statute. I can put it that way. There's perhaps some questions in the chat which I haven't seen. I don't know if you want to chime in here, Roman. Let me see if I can.
Yes, of course. Better to answer them now.
Sure. Are you able to read something out for me? I'm just, okay, I think I've able to pull it up here. I'm looking at Anastasia's first question at 823. What's your view on the inclusion of cultural genocide to the list of genocide acts as it was initially envisaged by Lemkin? Is it, in your opinion, a realistic prospect in the context of amendments to the Rome Statute? I don't see amendments to the Rome Statute as being very likely. I think the crime of aggressions amendment was sort of envisaged in Rome and sort of unfinished business, and there was a political will to make that amendment, but the process for amendment of the Rome Statute is very difficult. I can give you one example. I am presently on the advisory committee for legal text for the ICC. So I'm the elected representative of the 800, 1,000 lawyers that are on the list of counsel at the ICC. We get one representative. I've served in that role for a few years. I have to step down in a couple of years. And there's a proposal by states to, and this is a bit of a sidetrack to say, what happens if a judge dies during an ICC trial? And the conventional wisdom is you'd have to do a retrial, and that would be very expensive. And let me just say, a lot of judges aren't particularly spring chickens. They're a little bit older. And so the ad hoc ICTY and ICTR, the Yugoslav Rwanda tribunals, eventually ended up getting in scenarios where they had judges that unfortunately passed away during trial. And so they had to amend the rules to allow what was Rule 15b to have a replacement judge. And a replacement judge came on at both courts and effectively would watch the videos, read the transcripts, certify that they had read the record, and they were ready to be substituted in, and there was a pause in the proceedings. And so what's curious is when the states met in Rome, they said, we don't want to have a replacement judge. We don't think that's fair to the accused. We'll allow an alternate judge to sit for the trial. And so instead of having 3 judges at trial, we'll have this 4th judge as an insurance policy. And when one of them becomes unavailable, the 4th judge can substitute in. That provision exists. It's never been exercised. And when they were doing the Yekatam Ngaisona Central African Republic trial, during COVID times, the prosecution made a proposal saying, we should have a 4th judge. We're in perilous times. One judge gets COVID, our trial goes away. And the ICC didn't include that. And so the ICC states view putting a 4th judge is very expensive. They rather have a replacement judge, which is a bit cheaper, but then there's a big delay and that doesn't cost. And so it would be really easy fix just to amend the statute. But I think all of the states themselves are saying, we view amending the statute as so difficult, we're not going to even try to do it. And so that's a long story to say, amending the statute is probably not a realistic prospect to do very much, even in a very simple procedural question, Anastasia, if I can answer your second part that way. Cultural genocide is probably controversial if it goes beyond the 5 acts from A to E and under Article 2. And I guess the most famous example was this, it was the suppression of Aboriginal culture in Australia, and the programs where Aboriginal children were taken and adopted by others. Was that a genocide? Is the sort of suppression of all Aboriginal culture been effectively a genocide act? And there's lots of authors that say it probably crosses the line, but the problem is the law doesn't really give that entitlement. So I can't think we can really talk about cultural genocide so much as we can only really talk about these acts. And the question is, can you find them? I had a question the other day. I guess if you see destruction of culture, destruction of, in the former Yugoslavia, when there was a genocide going on, mosques were destroyed and other items of Bosniak culture were also destroyed. And so it's not so much that you're charging that destruction of culture as a crime, but it's really strong evidence of singling out of that group. And so cultural destruction is evidence of a genocide in general, and I put it that way. If I can answer your question any more full. Great question about the role of Belarus in the alleged deportation. I unfortunately don't know enough about the alleged deportation, the role of Belarus in that. Effectively, my last slide, and I'm hoping we will get to it in the next 15 minutes, talks a little bit about modes of participation. And Roman, I'm happy if people want to have the presentation, you're welcome to share it. That table that appears at the last slide makes a distinction of what are modes of participation under Article 25(3) of the Rome Statute, and what particular acts would constitute certain modes. And you don't just charge at the ICC a crime, but you have to charge a mode of participation. And there's a lot of confusion there. And I hope that table clarifies it a bit. And you can see the evolution as well over time from the ad hocs. And so now the answer to your question is going to be a really generic one, which is, depending on the role, if they meet any of the modes of participation, then they're probably going to be susceptible. And I'm not talking about Belarus as a state. I'm talking about individuals assisting. We only have 2 individuals subject to arrest warrant. If there's individuals that have participated in one form or another that rise to a form of criminal participation through a mode of participation, then they can be brought into court. Now, because it is a treaty, the state of Belarus could be hauled into court as well if we get to that level of intent. We have an act. We can all say forcible transfer of children as an act. That actus reus element met, there's no question, based on particularly the old prima facie strong case that's been brought by the ICC prosecutor. The real question here has to be the intent. And I have a couple quotations here which may be relevant. They don't tie directly to the transfer of children, but maybe to other acts. And the second part of this question here from Pavlo, can these actions constitute war crimes or even a crime of genocide? It's possible ICC issue arrest warrant. I guess the one thing I want to clarify for you is the Rwanda tribunal experience and all shows us that you can charge a single act as genocide, crime against humanity, and war crime all at the same time. They all have different elements. And so when we charged the Rwanda tribunal genocide, there was almost always a crime against humanity extermination charge. And we most often got a conviction for the crime against humanity extermination. Now, if you have 2 convictions for the same act, they have different elements, so you can charge and convict on both. What's important to know is you can only sentence once. You can't give someone 2 separate sentences. So the sentencing, the jail time as an individual would be 1 sentence, but certainly multiple convictions and the same acts. And if you look at the recent ICC charging history in Ntaganda and Ongwen cases, you'll see every single war crime is charged as a crime against humanity. It's just like a mirror image. Everything is doubled up. Every charge is double. I'll leave it at that. And I can't profess to know the facts of Lukashenko sufficiently to drag him to court yet, but I'll leave it to others to share. I'm looking here now at Dr. Lauda's comment. Your team's working on developing a methodology where Russian informational warfare can be used as evidence of intent. That's really helpful. And it'd be great to touch base on this topic. Okay, I'll leave that one there. I'm looking at Andre's Article 2. Could each single action from A to B be considered as an act of genocide separately? Answer, yes. Each act you could charge separately. And obviously, you could have 5 crime scenes with 5 different acts. You could charge 5 counts of genocide. Absolutely. Now, it just depends on your charging philosophy. You could charge one count of genocide and allege 5 different acts, or you could allege 5 acts of genocide and I'll let them freestanding. So there's a different philosophy. Certain indictments at the international level had a broad charge and various facts to support a single charge. And other prosecutors rather make them itemized and made each act a separate count. It's not settled, and you have flexibility as prosecution to charge it. If you charge one thing as a broad crime with several acts, the benefit is if you don't prove all of them, you've got one count and you're going to win on it. If you charge it multiply, you may not get all of them, and then the story in the press after judgment will be, well, there was some acquittals and there were some convictions. So it just depends on whether you want to particularize it or you want to have a broader charge there, if that makes any sense. And I'm reading the second part. Yeah, you can charge forcible transfer as a cause of genocide, and you need not have any killing. These all stand freely. So if the Rohingya, if there's evidence of all of those acts stand freely, you don't have to have all of them. And so the whole point in the Akayesu example is you can have rapes amounting to genocide with no killing whatsoever. So you don't have, those not cumulative. You don't have to have all of them. Just forcibly transferring children with the intent of destroying, let's say, a national group. And you have the evidence of the intent that we're doing this to make sure there aren't anybody from this national group ever living again. Absolutely, charge alone, just as an Act E. So great question. I'm going to go a few more slides. If we go to the next one, please.
Yes.
Great. Okay, so a couple quick points here in the 10 minutes we have remaining. So this is on the left side, provisions from the Genocide Convention, and then a little bit of my analysis on the right. What I want you to notice is that in the convention, although it's a treaty signed by states, you'll see the underlined Article 5, we're talking about persons. We're talking about individual criminal responsibility. Now, Article 1, I already mentioned that states, the contracting parties in Article 1, undertake to prevent and punish. So this is a state obligation under state responsibility. So state responsibility means one government has promised to do this, and they can get brought to court, to the International Court of Justice, the World Court in The Hague, in the Peace Palace, and said, you failed to live up to your treaty obligations. And a judgment is probably going to say, state in the example of Bosnia versus Serbia, Serbia failed to punish Mr. Mladic, failed to arrest him. We find that Serbia violated their obligations. Does anyone go to jail from the ICJ? No. Is there a judgment against a whole state? Yes. What's the satisfaction? Just this judgment. They could issue a judgment saying you owe so many millions of dollars. They don't tend to do that in the genocide cases to date. So the obligation, what's interesting about this treaty is it has obligations both on states, and it requires states to punish people as in matter of individuals. So this is where individual criminal responsibility, individual criminal law, and public international meet, and it's a unique special aspect. So all of this to say that if you're charging a genocide case in Ukraine, it probably means that your government should also be bringing a case to the ICJ as well. And that the evidence in your criminal case is going to be evidence against the state failing to prevent or punish. And that was the case. The most important evidence in the case of Bosnia versus Serbia was evidence that came from the Yugoslav Criminal Tribunal, including case from Mr. Mladic. Okay, last paragraph listed on the left is that you can bring cases to the ICJ. And those are the examples I meant. And what's unique to the Genocide Convention is you'll see in the second line that it talks to that you can bring cases to the International Court of Justice for the 1 interpretation, 2 application. That's in every treaty. Questions of interpretation and application. Those of you who study public international will know that's probably the standard for referral clauses, compromissory clauses in treaties. But what's unique to the Genocide Convention is they threw in the third basis, the fulfillment of those obligations. So this is an extra belt and braces perhaps, but this extra thing. And so the judges in the Bosnia versus Serbia case said, this is an even stronger obligation. States have all said that they will promise to fulfill the prevent and punish obligations. So higher level obligation unique to this convention. Next slide, if you would, please. So the question most often asked is, how do we prove that this particular act amounted to genocide? So we got to prove that genocidal intent. And how does one prove intent? Well, my easy answer is the same way you would do it in a domestic trial for all other offenses. And the most common way is, what did the suspect say? What were the words coming out of? What was the utterances that gave us some indication as to the motivation and reasons behind? Now, international courts have held that trial courts can infer that specific genocidal intent from circumstantial evidence. So you can have words, that's evidentiary gold, but if you don't have words, you can infer it from the acts. Really important. I'm jumping to the last bullet point. There is a media case, Nahimana et al. This is the case of people on the radio in Rwanda. And the judges found, and it's been affirmed, that the judges can infer genocide intent from the factual patterns, not from the words necessarily, but it has to be the only reasonable inference, okay? Now, what is really strong evidence of that genocidal intent is, and I'm looking at the green text here, specific targeting of the group. And as I mentioned earlier, including cultural things that belong to that group, is going to be that targeting because, such as, singling out. Let me give you one example. In the Cambodia case 2 million people were perhaps killed between 1975 and 79 by the Khmer Rouge. Were the mass number of those killings found to be genocide? No, except by one dissenting Cambodian judge. Why? Because those who were killed were targeted because of, shall we say, a political non-Khmer Rouge belief. So it was just whether you were Khmer, a political affiliation, or non-Khmer that decided if you were going to get killed. And so most killings, although there's a body count, a really high one, crazy number of deaths, such a huge extermination, people automatically think such a high body count has to be genocide. But the judges and the law don't allow that because it's not the right group. But there's an exception. There were 2 small groups, and there were genocide convictions entered in this case too, but only for ethnic/religious Cham, which is a minority group it's a Muslim minority ethnic group in Cambodia, and they were targeted and killed. And so those killings were viewed as genocide because they were targeted as Cham because of that fitness. Now, Vietnamese killed is a really more interesting example for the Ukraine. Why? Because it's a national group. It's not ethnic, it's not religious, it's national. And so what's really important in Cambodia is that all of this group affiliation was viewed as matrilineal. You took the group from your mother. Your mother's always known. And so if your mother was Vietnamese, you were viewed as a national Vietnamese in Cambodia, regardless if your father was Cambodian or not. And so we have these fact patterns where the mother's Cambodian, the kids are viewed as Cambodian. The mother's Vietnamese, the kids are viewed as Vietnamese, and they're both killed and the father spared. And the reverse scenario where the kids aren't killed because it's only the father that's Vietnamese. So you can see that sort of singling out of conduct and the cultural deception of how group appurtenance is passed down and the targeting of Vietnamese because of their national group affiliation shows a genocide. It's really the exception to the killing, but because of that singling out, the judges are comfortable arriving at that intent. What's really also important here is the derogatory language, okay? In the Rwandan context, it was kill the cockroaches. In the Holocaust, it was kill the Jewish rats. You can imagine how you can motivate people to kill only by using that dehumanizing language. Next slide, please. And I know we've got just a couple minutes. Akayesu, during the rapes, said this famous quote, "Never again tell me you don't know the taste of a Tutsi woman." And those words coming out of his mouth, targeting those rapes against the Tutsi women, they said that's genocide, that's harm intended to destroy Tutsi women. I prosecuted this case of Nira Masuhuko, was the Minister of Women's Affairs. And she said, rape the young pretty ones, the ones that refuse to marry you. And so again, targeting the raping against a particular ethnic group. Saromba, case I helped prepare, he said, destroy the church. There are demons inside. Again, the demons in this case is dehumanizing language to the ethnic Tutsi that had gathered, the 2,000 men, women, and children that were in his own church when he ordered the bulldozing that ended up killing all of those people inside with one survivor. Now, the Yugoslavia Tribunal only entered its first conviction for genocide against General Krstić in 2001. So after many trials, it's limited to Srebrenica. They've had multiple attempts, and they were just a few judges away from finding genocide in other areas, other municipalities outside of Srebrenica, but historically we're now limited, unfortunately, to just having a finding of genocide occurred in Srebrenica in 95. Now, what was the evidence that helped the judges decide that he had the intent? There's a video clip of an intercept in the next slide, if we could play it, and you'll hear this intercept. I think you have to push the play button in the bottom left.
Yes.
Thank you. And you'll see the text as well. Oh, we stopped somehow.
Okay. Sorry. Let me try again.
We'll try again. It's not very long. I realize we're almost at time.
I will share the screen again because we have small internet connection problem.
Thank you all for your patience. Effectively, you'll see words where he says, destroy them all, kill them all. And this is so it's the 9th slide. And again, if you ask Roman, I'm sure he'll be in a position to share this with you if you'd like.
1 minute, please.
Sure. There you go.
Maybe without sound, but we can read the subtitles.
This is true. So this is the general on the left. Thank you so much. That was really worthwhile. So the really interesting point here is, and as a prosecutor, you love this. This is the Obrenovich, the subordinate officer, doesn't hear him saying not a single person should be left alive. He says, what? And he has to repeat it a second time. So there's absolutely no doubt what Krstić wanted to happen because he has to repeat it. He really says it almost 3 times. And what's interesting is this is a national state security authority interception. It's still admitted into court. There's no question as to the authenticity. It's established. What helps with the authentication of this evidence? Obrenovich, one of the 2 participants in the phone call, testifies. He's an insider. He says, I had this call. Krstić, yes, that's my voice. That's Krstić. He says, kill them all. This is in August. This is after Srebrenica took place in July, but it's certainly very relevant. If someone's saying, kill them, destroy them all, don't let a single one live in August, you have the idea that you can infer what he was saying in July. This is the last one, and the only thing I'd say is you're welcome to share this. And what you see on the right side if you look in this one column that lists 25.3a for committing, it's listed in the number of the Rome Statute, A, B, C, D through F. And you can see that there's various forms of committing. So you can effectively charge someone with committing genocide if they've done it individually, done it jointly with others, or through another. You can convict someone of genocide if they've ordered it under B. C, aiding and abetting, really important. Group participation, like most international forms, can be charged under 25.3d. Now, the real point here for genocide is 25.3e as in echo, inciting directly in public others to commit genocide. And so this is a mode that might be really interesting for people that we don't have to prove for inciting that the genocide necessarily took place. There is one quotation here. Paul Gubarev, the Russian-appointed People's Governor of Donetsk region on 11 October 2022, and I quote from a source I haven't verified myself, "The Ukrainians are Russian people, possessed by the devil." Sounds a lot like my Soromba case. "We are coming to convince them. We are coming to convince them not to kill them, but if you don't want us to change your minds, then we will kill you. We will kill as many of you as we have to. We will kill 1 million. We will kill 5 million. We will exterminate all of you until you understand that you've been possessed and you have to be cured." Now, I pose the question to you. Is that directly and publicly inciting others to commit genocide? Is that singling out Ukrainians as a national group as such? There might be a prima facie case there. It's really rather for the facts to be borne out, whether that was his intent. And it certainly helps if there was killing that followed, that targets. But again, the incitement doesn't necessarily require it. I know it's 5 minutes after the hour. Thank you for indulging me a few minutes. I'm still up early and about to have breakfast, but I know it's keeping you from perhaps your dinner. But I want to thank Roman and the Center for its allowing me to participate. Thank you for your questions. I'm happy to answer questions at a later date by email if that helps. Feel free to reach out and contact me.
Actually, we have several minutes more for Q&A if you're willing to engage.
Absolutely, absolutely. And I will put my work email in the chat here as well. But go ahead and feel free to pose a question either in the chat.
Yes. Do you have a book advice on genocide?
A book? Oh, goodness. I would probably say if you're interested in the development, the history of it, then I would look at the Philip Sands East-West Street, watch some of the videos about that first and see if it really interests you, and then you could go and spend more time and read the book. The others tend to be more about the Rwandan genocide or a different book about the Cambodian, and so it's more a regional sort of focus. There isn't one that jumps out that I would say. Feel free, if you tell me what your main interest in, send me an email. I can do a bit more of a literature search for anyone who's really more keen. But I would probably spend, if you wanted to dedicate more time, I would probably look at like the case law databases for the Yugoslav and Rwanda tribunals where they found genocide convictions and see what it was that convinced them, the judges there, what kind of evidence would be probably the most practical approach. The Rwandan cases, I think, are a little bit more, when you kill 1 million people in 100 days and it's all targeted mostly on what was the ethnic group on an ID card, they were factually simpler cases, I have to admit. And you're dealing with a much finer nuance in the Ukrainian context. But questions, I'm here and absolutely happy to stay. Yes. If anyone has any more questions. I see, Andre, you didn't mention Article 3. I have a question about the PC, incitement to genocide. I think I might have passed that on a little bit. If you have a question, go free to, Andre, feel free to pose it or orally. And I see that Ivana has put a hand up as well.
Yes, Ivana, please unmute yourself.
Yeah, guys, thank you very much one more time for the great lecture. It was a
Oh, you're
compilation. Do you hear me? Yeah, I hope.
Yes.
So, yes. I have a very concrete question because my job currently is actually connected with international crimes. We are from the European Union Advisory Mission trying to support document investigation and prosecution. So obviously when we are touching the intent and genocide, there is a question about intent. This is like the most complicated to prove.
However, this is the most
have
challenging, I wouldn't say complicated, just difficult from an evidentiary point of view. Yeah, exactly. Carry on, Ivana. And I'm really so happy that you're here, and I'm really wishing you so much luck. And if I had an EU passport, I'd probably be next to you now.
Can you strategically speaking, help me out? Because there is several areas that we are working. If you had already about the deportation, it's more or less completed, let's say, case because it's arrest and it's going on. Another pattern that is traced are conflict-related sexual violence. How do you think here? Where are our possibilities? Which cases should I look for?
I think the hints I've sort of given in this presentation, what has helped judges arrive at a sufficient factual basis or a sufficient inferential basis to find facts of a genocidal intent? First thing is, do you have anyone talking about, in this case, the real question here is we're talking about Ukrainians as a nationality. The group here isn't going to be racial, ethnic, religious here. And so nationality is the key here in terms of the group. And so as the evidentiary gold that I talked about in some of those slides is, what did the suspects say? And did they mention Ukrainians as Ukrainians, to victimize only the Ukrainians? And so you have to be led by the evidence in your charging. And if you have someone who's seeking to cause any kind of harm in a criminal act, because you've got the A through E, you shouldn't just be looking at killing. And I think you've already mentioned sexual gender-based violence. So that's B, physical harm. Your act is going to be satisfied. And you wouldn't be looking at these cases unless there was something that's qualifying under A through E. So I'm not so worried about your acts. And you're already saying, what about the intent? So the intent is words of the accused, evidentiary gold. Now, the benefit these days now is, where do people put, where do they say things? They speak, but they also put things in social media. They send text messages. And so and then there's ultimately some radio communications. And so that's going to be like the interception that we saw between the two military officials of the Serbian Bosnian side of the conflict, Krstić and Brandeis. That's basically state security doing an intercept, and it leads its way to court. But this is almost a smoking gun because you have the words of the accused. And so I can say, you look for every possible menu to get the words of the accused. And if you don't have them, then remember I talked about the Cham and the Vietnamese being singled out? There wasn't that people were talking, it was the acts themselves showed that people were being distinguished based on nationality. If you were Cambodian, you went to the other side and you were let to live. And if you were Vietnamese, you know, they put a plastic bag over your head and killed you. And so that, you don't need words if the acts alone show the distinction being made on a nationality basis. And aside, there's no other magic formula besides that. You've got to find facts that show that distinction. Now, I read off a quote for someone as well. I think there's strong cases for incitement perhaps here. And incitement is a crime of words. And so you don't need to show that there was necessarily something that followed. Let me give you an example. If I yell fire in a crowded movie theater, I can go to jail even if no one's killed later. You're not allowed to do that because there's just a risk. And so attempting, again, you can also charge an attempt. And if I was charging instigating, someone using words, I would also charge an attempt. I would also say they were hoping that people would listen to their words and go ahead. Now, the question is, was there some sort of act in furtherance? So I guess, Ivana, I'm wishing you so much luck, but I guess the facts that I would say lead you most is going to be look for words, look for social media, look for texts. You know, I spent 3.5 years at the Lebanon tribunal, and we ended up getting convictions for the crime of terrorism, all based on phone evidence. And we didn't have very much content. We just had someone calling someone at a particular time and from a particular place. And the judges were able to infer that this was all part of an assassination attempt. And so called data records without content can be very powerful evidence. If you've got called data records, you have SMS content. If you can get SMS content or any other sort of social media or other communications, that's going to be your gold. And if you can't get that gold, you've got to find fact patterns that show a distinction being made. And
thank you.
If you don't,
I still have another question.
Sure. And if you don't have that, you probably shouldn't be charging genocide and stick to your war crimes and crimes against humanity. And that's probably fine as well. Carry on. Next question, Ivana.
And the next question, actually, Anastasia already initiated about the culture. I'm a fan of Timothy Shilston. You probably know him as well. He brought these 9 features of the genocide, bringing from historical patterns. So my idea was like to have a strong reasoning, just of a contextual, collateral, a historical, that it is not a new for us. There was the lower 3 grains in the past in the Soviet Union. There was like to create this intentional from the past. Would it work like to have this overall reasoning for the case?
I think that would help you. And remember, as a prosecutor, part of your job is just to educate the judges. And I can tell you that at the Rwanda and Yugoslav tribunals, we made wide use of expert witnesses to sort of lay those sort of foundations. Remember I said some of the evidence was like kill the cockroaches. We had evidence of people saying kill the lice, and when you kill the lice, you have to kill the eggs. And why did they mention that? Is because they were trying to instigate people to kill children. And if you say you're killing lice and eggs, then the farmer kind of perpetrator understands and is happy to do that because it's not a human, they're dehumanized, they're just lice eggs. And so how did we do that? We called linguistic experts. And we said, in your language, when you say X, what's the interpretation? How should one understand that? And so you're talking about giving a broader context. And I think you want to start thinking of who would be the experts, because you have to have someone introducing that, perhaps produce a report, perhaps testify, ideally both, that give some context. And I think it's also fair to mention the Lebanon tribunal, we also relied heavily on experts to interpret this call data evidence as well, because there's 1 million phone calls per day. How is it that we zoomed in on these particular ones? I hope that helps, Ivana. It's a gargantuan task. But again, if you don't feel that you can prove beyond a reasonable doubt, you have other arrows in your quill, and use the war crimes and crimes against humanity, and be selective in your genocide case. And then remember, anything that you want to prove is probably going to be really helpful for an ICJ state claim. And perhaps you can get some sort of resources to help build that up and document it. And I don't think you should be shy in asking intelligence agencies for those intercepts, because that's going to be tremendously helpful. Satellite imagery, whatever you can get.
Dear participants, maybe as a last comment for today. In the case prosecutor against Radislav Krejcich as a part of the International Tribunal for the former Yugoslavia, it was said that the harm must result in a grave and long-term disadvantage to a person's ability to lead a normal and constructive life. I wonder what is the limits of the normal and constructive life are, because the judges didn't go into the details.
That's a great question, and I glazed over that, and I thank the participant who asked that. My Cyrillic reading isn't good enough to pronounce the name here. And so when we looked at the elements, it said in whole or in part. The judges have interpreted that at the ICJ, and you mentioned in Kirstich, a substantial part is the answer. And why is Srebrenica singled out? When you killed 8,000 men and boys, the judges reasoned that that population couldn't reproduce, right? And so we're looking at biological destruction. You can have a population of females, without the males, they won't reproduce, and vice versa, right? So that was the conception and fitting that. Is there a whole lot of jurisprudence? No. I'm not so bothered that, there's the acts there. Let me make another point here. We're talking about groups, but you as prosecutors can help define a smaller category of groups. And in the Kirstich case, they weren't talking about Bosniaks in all of Bosnia. Now, just to be really clear here, another point I wanted to make is when I say Bosniaks, most people are going to say you're talking about a religious group under the Genocide Convention. But in fact, if you read the fine print of Kirstich, they're defining Bosniak as a Bosnian national. So it's a national group. So Kirstich is good jurisprudence for the nationality as a group. So second point is they define the group not as all Bosniaks, but as Bosniaks of Srebrenica. So they define the geography much more narrow. Why? Because they can say that group, as Bosniaks of Srebrenica, they cannot reproduce. And that's the quotation. They can't live a constructive life anymore. That amounted to substantial destruction. So there's two things. It's not a very clear test. It's got to be substantial, but you get to define not just, you have to define the group, but you get to define the geography of that group, if that helps you. So, and again, is there a pattern as the ICC elements of crimes developing here? Yes. So I'm not so worried about meeting the elements as to the acts. Genocide, as Ivana's questions all went to intent, that's where the evidence really needs to get compiled. That's the case. And that's the challenge here. And the real challenge is everyone in the whole world sees this as war crimes and crimes against humanity. You have to get those horrible quotes like, we will destroy you because you're Ukrainian and you've got demons in you. That sort of evidentiary gold of words coming out of their mouth, that is, for me, cases where judges are going to be more comfortable. And remember in Kirstich, there was one American female judge, Wald, and she wrote in her memoirs that she had to convince her fellow judges that there was enough case for genocide there. So it just takes one really good judge to believe in your evidence of that distinction on group of pertinence, and you've turned the tide. Is that probably a good point to end?
Yes, sir. Professor.
Thank you all. I hope that helped.
Yes, it did. Thank you for your presentation. I will definitely share the PowerPoint with registered participants.
I see more questions. Feel free. If you go up in the thread, you'll see my email. It's ga.townsend@Haagse Hogeschool, hhs.nl. So thank you all.
Thank you. And a brief reminder that tomorrow, 11 o'clock Kiev time, Center for Civil Liberties will conduct its grand finale, final panel discussion on the Rome Statute ratification in Ukraine. Please stay tuned. Thank you very much.
And wish you all best for your International Justice Week. Thank you so much, Roman. Really a pleasure.
Thanks
you all. Yulia, Ivana, great questions, all of you. And again, the door is open if I can help in any way.